Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to take your immigration questions. So if you have an immigration-related question, go ahead and put your questions in the comments right now, and I will go ahead and answer your questions. I'm pretty sure you know if you're going through the process, if you've been through the process, if you're about to go through the process, then you have that nagging question, and now is the time to answer it. Why not take advantage of me, a U.S. immigration attorney, being here and available to answer your questions over the next half an hour or so. Now, as your questions come in, I'm just going to tell you a little about me. I am U.S. immigration attorney Sharifa Tharpe, and I help clients to get their green cards and status in the United States. You can go to the link in my bio where you can learn more about me and learn and get the contact information to schedule a consultation if you need one. So how long do you think from one I-130 to adjustment of status take? So the adjustment of status process, I would say prepare for an 18-month process. It depends on who's applying for you. So for example, if you do qualify for adjustment of status, that's also another thing. You want to make sure that you qualify. But once you do qualify and you apply, prepare for an 18-month process. That's the average. It could be less, could be more, but about 18 months. TD Acres, that's right. Fellow woman of power here. So keep your questions coming because I am here to answer your immigration questions. I'm here every day and I'm on a little late, but I did not want to finish the night without touching base with you all and being available to answer your questions. So put those questions in the comments because I enjoy answering your questions. I really would like to be available to answer your questions. So if you would like to learn more about me, I'm going to talk about how you can get in touch with the firm if you don't want to ask your question here, or you know that you're going to need a personal legal consultation. You can call 561-405-4889. There is a scheduling coordinator who is available until 11 p.m. Eastern time to take your calls and schedule your consultation. However, keep in mind, you could be up at 3 in the morning and you decide, I really would like to take action and get in touch with the attorney. What you'll do, you can call that number and then after hours receptionist will also answer the line and also take your name, your number, and then the scheduling coordinator will get back in touch with you on the next business day. So go ahead and put your questions in the comments while I'm here to take your questions. So I don't see any questions. So while your questions are coming in, what I'm going to do is talk about a particular topic. And the topic I'm going to talk about is applying for the green card on your own if you are facing mistreatment by a U.S. citizen or a legal permanent resident spouse. If you're under 25, a parent, U.S. citizen or legal permanent resident parent, or if you are the parent of a son or daughter 21 and up and they are mistreating you. Now, if you have these relatives and they are mistreating you and you are without status, there is a way to apply on your own. And so what does mistreatment mean? Mistreatment means that they are verbally abusive, they are emotionally abusive, verbally, mentally, and this could be name calling, this could be gaslighting, this could be control, this could be manipulation. These also qualify individuals to apply for the green card on their own. So I want you to keep that in mind because there's a misconception out there that in order to qualify for the green card based on mistreatment, that you must have a police report, you must show evidence of physical harm or abuse or injuries. That is not the case. So Malia, how long after filing do you do the biometrics? So right now I'm seeing about 3 to 4 months, and it also depends on the application. But with the adjustment of status process, it's about 3 to 4 months, and this terribly backlogged. Pre-COVID, it was 6 weeks, and now it has gone. And keep in mind, some individuals are going on 6 months without getting a biometrics appointment. So while I'm giving you averages here, average times, it could go longer. If you do find that it goes longer, definitely call the number and make sure that there's nothing pending on your end, that everything is okay. They're not waiting for anything for you to send anything. So keep those questions coming. So far, I've had 2 very good questions, and I would like to answer your questions. That's why I'm here. My main priority is to answer your immigration questions. So feel free to put your questions in the comments, even as I'm talking. I'm talking about a particular topic tonight, and that's why your questions come in. So that topic is applying for the green card on your own. If you are being mistreated by certain relatives, and these relatives are U.S. citizen or green card holder spouse, or if you're under 25, the parent, or a citizen son or daughter who's 21 and up. If they're mistreating you, it could be emotionally, physically, definitely physically, but keep in mind, physical abuse is not required to apply for this. It could just be emotional abuse, financial abuse, or it could be mental abuse, and that would still qualify as abuse for the green card. Now, when you apply, here are the number 1 concerns that I get from clients when they are really considering applying for this. They're going through a hard time with their relative. But one is, will this cause their spouse to be arrested or investigated? No. So this is for the purpose of supplying evidence to the USCIS is for the purpose of determining whether you qualify for the green card based on the mistreatment and nothing else. Will this get back to your relative? No. This is extremely confidential. It is even under the law, they cannot disclose any of your information. They can't call the relative. They can't verify anything from the relative. They're just going to be considering the believable evidence that you provide to them. TD Acres can apply if I'm not being abused. So absolutely, there are ways to apply for the green card if you're not being abused as well. And of course, there are a number of ways. There's through employer, there's through other family members, so a U.S. citizen or legal permanent resident spouse, parent, or son or daughter who's 21 and up. So of course, there are other ways to apply. However, for individuals who are being mistreated by their relatives, sometimes they face the obstacle of not being able to apply for the green card because their abusive relative is not doing it for them. They otherwise would qualify through that relative, but the relative isn't doing it, or the relative is abusing them. And so this is a way to give them an out or give them an escape from the relationship that's harming them. So Nals, my husband haven't had permanent steady job. Do you think it's possible we could still get our visa? So, you know, it may be possible. However, they do like to see that you do have strong commitments to your country. And if you don't have a job, it's kind of difficult to show that. But it does not disqualify you from applying. You don't necessarily have to have a job, but you do have to show that you have strong commitments to your home country to be able to go back to your home country after you have visited the United States temporarily. Can status be changed if one goes to the U.S. on a work permit? So usually if you come to the United States on a work employment-based visa, that may be a possibility, but it just depends on how you qualify for to change over your status. What if I don't have any of the above? then if you don't have any way to qualify for a green card, what you could do is you could sign up for the diversity lottery. It's like the lottery for the green card, and that it could be that could possibly be one of the ways that you get a green card if you have no other way of qualifying. My husband just filed for me. Is it okay for me to leave the USA while the petition is pending? So great question, Princess Lude. I don't know what your situation is. I don't know what you are, what process you're going through, and I don't know what the status of your spouse is. However, normally when you're applying for the adjustment of status, you have to ask for permission before leaving the country. If you do say overstayed, then your husband petitioned for you, then you left the country, you could face big trouble and get stuck outside of the United States. So Princess Lude, get legal advice before you leave the country. Make sure that you can do that. Barbie Hattie, I have a niece. Can I carry her to get a visa? So you wouldn't determine whether or not they get a visa. Your niece would have to show that she has strong ties to her home country, that those are strong commitments that would allow her to return to her home country. So we got married in April. I came in March. So Princess Lude, it's hard for me to, I give general information here, not personal legal advice. So I would not be able to tell you whether you can travel unless I know all the facts here. Rich Chick, hi there. Rich Chick, go ahead, put your question in the comments. That's why I'm here. Now 87, how you go about getting a U.S. work visa. So you'd have to qualify through an employer. They're probably going to be looking at how you qualify, whether you meet the requirements, what are the needs of the employer, what are the needs of the country, and so forth. There's so many employment-based visas that it really depends on what you qualify for. My filing is taking forever. What's going on? That's Rich Chick. So there is a backlog, and it really, that is one. However, check with them. Call the USCIS if that's where it's pending, and ask them what's going on with your case. It could be a number of reasons, and without knowing your particular circumstances, it's hard for me to give you any further details. I know that is a common complaint right now because, and of course, COVID has made it worse. So she's a child. So Barbie Hattie, unfortunately, even her being a child wouldn't necessarily qualify her to get a visa through you. So keep those questions coming. So far, these are all great questions, and that's why I'm here. I am here to answer your immigration questions. So Monifa Love, my husband is a 10-year green card holder. Can he file for my son who is in Jamaica? So if your son is under 21, unmarried, then your son could go along with you if he files for you. Now, he can also file if you did get married. So if you got married before your son turned 18, he would be considered the stepchild of your husband, and he could apply for him as his own child. The case is already in Jamaica. They sent emails saying that it's not in the US anymore. So, yes. And who is applying for you? So that's a very important detail here to know who's applying for you, how old are you, and are you married or unmarried? I've been waiting for 10 years. Okay, so Rich Chick, it may be the processing time. So your grandma. So now grandparents can't directly apply for grandchildren. So that's one thing. So your grandmother would not be able to apply for you. So if your grandmother applied for you, then that you're not going to qualify. It's only your parents who can, your green card holder parents or your citizen parents. But your grandmother would not be able to directly file for you. What happens is if your grandmother filed for your mother, your parents, so if your grandmother filed for your father or your mother, and you were under 21, you could go along. But in the case that you're 21 it hasn't been, sounds like it's been approved, but there's no immigrant visa number available yet. So yeah, your mom and siblings are also on the filing. So rich chick, what may happen here is that you may age out because you turn 21. You have to go along with your mom. You have to be under 21 and unmarried. And so if you've reached 21 and there's no immigrant visa number that's available to you yet, then you could have aged out. But there is a formula that's available to determine whether you still can go along. But it all depends on where you are in the process, whether there's an immigrant visa number available for you. So definitely get legal advice if you would like to get more information about whether you fall under that exception. Call me, Mrs. Ford. He filed when I put in my papers. So let's see. Hi there, Amanda. So Manifa, thanks. Can he file for both of us now with the 10-year green card? So a green card holder can sponsor their spouse. Right now is a good time for green card holders to sponsor their spouse because there's no wait time for the immigrant visa number. And what that means is that once they approve the I-130, it should go straight through to the embassy for an interview. And if your child is under 21 and unmarried, which is, it seems my child who is 11 years old, he would go along with you. And he could also qualify as a stepchild of your spouse. So that you could qualify there. Now, I don't know the rest of your circumstances. So I'm just giving you general information. So keep those questions coming. Let me see. It's been approved before I turned 21. So rich check, even though it was approved before you turned 21, the question is there an immigrant visa number available? And if that immigrant visa number becomes available, then what they'll do is take the time between the time that it was filed to the approval date and subtract it from your age. And if your age still falls under 21, then you could go along still. So it really depends on where you are in the filing, whether you're ready to go to the interview. So at the time that the immigrant visa number becomes available, that's when you can attend the interview, or they're gonna get ready for you to attend that interview. And it's at that point that that they could apply the formula to see if you still qualify. So rich chick, it's complicated, and that formula is going to depend on your particular circumstances. So as you can see, it's a lot of information, and so it's best to do it in a consultation. So just schedule a consultation. You can call 561-405-4889. And if you have aged out, you can also figure out a strategy to continue going forward with some sort of other type of green card process, maybe through your mom. So my mom sponsored my dad since 2019, but he get approved, and now is 2021, and still we didn't get anything. So always check on your case to make sure everything is processing. There is a backlog, and so everything is taking longer, but check on your case to make sure that there's nothing they need from you. How long before I get the biometrics appointment for the I'm thinking that's the I-751. Instrumental, it depends on, right now it's taking about 4 months, and maybe even longer to get the biometrics. Yes, the interview is what we have left. How long a waiver take to come out? So the waiver can take anywhere from 6 months, and if you're talking about the unlawful presence waiver, it can take anywhere from 6 months to 2 years, unfortunately. Hi, good night. If a green card holder married someone, how long will the person get through? So usually I would say prepare for about a 2-year process. right now. Keep in mind that could always change, but right now, as it is, you could prepare for a 2-year process. I live in Trinidad. I want to live in America. So, Daddy Pitbull, it really depends on how you qualify. And so if you really would like to make moves to come to the United States, the first thing you should do is schedule a consultation with me and we'll go through your qualifications. But how long it take my dad to get the green card, I'm not sure, Amanda. It depends on where you are in the process, what's going on in your case. What you can do is go ahead and check on your case because it's already pending. Now, if you were my client, then I would have a better idea. However, because you're not my client and I don't know your situation, I wouldn't really be able to give you an estimated time or... So can a person who overstayed independently apply for a green card? So unfortunately, not just by overstaying. As a matter of fact, that can stop you from getting a green card, and you have to qualify through a family member to be able to get forgiveness. Princess Dal, you're welcome. Nals 87, thanks for sharing the live. Do you know when the visa interview ban in Ghana will be lifted? So Lisa Craig 20, unfortunately not. What you can do is you can just keep tabs on the Department of State's website as well as the U.S. Embassy in Ghana to see if they provide you news of that information. So keep your questions coming because I'm here to answer your immigration questions about the immigration process. I help clients to get their green card and status in the United States. And so you're welcome, Lisa Craig. And so if you are thinking about going through the process, immigration process, whatever it may be, go ahead and put your questions in the comments because I'm here to answer your immigration questions. Now, if you don't want to ask your question here and you know that you're going to need legal advice, then you can also call 561-405-4889. Schedule a consultation. Now, there is a scheduling coordinator who is currently available up until 11 p.m. to answer your immigration, to take your information and schedule your consultation. So my daughter is 6 and living in Jamaica. How long will it take for her approval? So I would say prepare for about a 2-year process if you should apply now. And it depends on your status. If you are a U.S. citizen or you're a green card holder, you could be looking at an 18-month to 2-year process. Saving the Children 2021, can purchasing a franchise work for E2? Absolutely. Yes. So absolutely, purchasing a franchise can work as long as you meet the other requirements for the E2 visa. If you're an H-2B worker, how can you become a green card holder? So there's no direct path from an H-2B to a green card holder. You have to qualify. So for example, if your employer wants to sponsor you or a family member wants to sponsor you, then those could be possible ways. After I fill out my N600 form, how long do I have to wait for an interview? So what you can do is, it depends on where you are, where you'll be doing your interview. Go to the uscis.gov's website and look at case processing times at the service center in your area that's going to be processing you for the interview, and then you can get an idea of the range of time. How to get a green card? I want to live in America. So Daddy Pitbull 1, there are different ways, but there's through an employer. The most common way is through a family member, such as a U.S. citizen or green card holder spouse or parent or son or daughter, citizen son or daughter, 21 and up. How long for asylum-based naturalization? So once you're granted asylum, then a year later, you can apply for your green card. And then after that, 5 years later, you can get naturalized. So Gujo Proudly, I don't see your question. Can you use the Q&A feature so I can see your question? Honey Eyes Earth, really appreciate you taking the time to answer our questions. I really appreciate that. Thank you. Resident since 4/7/2017, asylum-based green card. Okay. So if you, then you have to wait 5 years from that date. From the date that you became a green card holder to be able to become a citizen. So keep your questions coming. While I'm here, why not take advantage of a U.S. immigration attorney being here and available to answer your questions? Can my brother or my aunt file for me? They are an American citizen now. Your brother could file for you, daddy people. However, keep in mind that that's taking a long time. It's taking about 14 years. So so if it's your only way to come to the United States, then of course pursue it, but you have to make sure that you're invested. Does leaving blank spaces on immigration forms result in rejection? Sometimes. It depends on what is left blank. Some things, now they did have a regulation that went into that if you didn't put not applicable in spaces, that they would reject it. That has been withdrawn by the Biden administration. But keep in mind, if you leave out very important information, that it could cause a rejection of the application. After receiving withdrawal acknowledgement notice on I-130 alien relative, can we reinstate the file? So, Gujo Prodley, that's a complex matter and it really depends on what happened in your case. So give me a call and schedule a consultation and then we can talk more about the details. So what's the difference between NA and NA? So not much difference. It just depends on how you write it. My mom entered in 2001 and got TPS. She left and came back in with parole in 2004. Does today change? So yes. It does change it, because what they're saying is that having TPS is not going to be able to. Now you said she was paroled in. Now if she was paroled in Jitter, it might be different, because what they're saying is having TPS alone is not enough to show that you had legal entry into the United States. However, if your mom was paroled in, it depends on how she was paroled in, but if she was paroled in as in given permission to come into the United States, then that could be a way to show legal entry. But keep in mind that this is general information I'm giving you, and it can get complex because first your mom had TPS, then she left, then she was paroled in. And so we would want to definitely look further into her facts to determine whether she would qualify as a legal entry. However, what the Supreme Court ruled today was that having TPS alone is not enough to show that you have some sort of legal entry into the United States, unfortunately. Because if you came into the country without a visa, you came in across the border without permission, then there's no way to adjust status unless you can show that you legally entered the country. And so the individual that went to the Supreme Court argued that TPS was enough to show legal entry. Unfortunately, the court found otherwise. So she was allowed to re-enter with advanced parole. It's kind of confusing, thanks. When the unlawful waiver come out and it takes 2 years. So it could take up to 2 years, yeah. So how long does it take a permanent resident in New York to file for an unmarried child over 21 in Jamaica? So it's taking about 5 to 6 years right now. Keep in mind that could